Hi, I want to thank everyone for joining us for the Embedded Racism in the Law panel. This is our fifth panel in our series exploring the multitude of implicit and explicit bias that exists in the law and policy. Really excited to have our three special guests, our panelists with us tonight. The title of our panel today is A Call to Action, Race, Social Justice, and the Role of the Legal Profession. Tonight, we're going to have three special guests joining us today. Our first is Teri McMurtry-Chubb, the professor of law at UIC John Marshall Law School. The second being Kelley, the Vermont National Lawyers from the Vermont National Lawyers Guild, And then our third panelist is Zamir Benton, a staff attorney at Legal Aid Society of New York. So I'm going to briefly introduce all of our panelists, and then each panelist will speak for a segment of about 15 minutes. And after which, we're going to open up the floor to audience questions. So please tune in, listen well, and join us with some questions after. So our first panelist is Teri McMurtry-Chubb. She is a professor of law at UIC John Marshall Law School. She researches, teaches, and writes in the areas of critical rhetoric, discourse and genre analysis, and legal history. McMurtry-Chubb is a leader in designing curricula to facilitate diversity, equity, and inclusion efforts. The professor served as president of the Association of Legal Writing Directors from 2015 to 2016, becoming the first person of color to ever head a national legal writing organization. She is the author of numerous publications, including the book Legal Writing in the Disciplines, A Guide to Legal Writing Mastery, and is a contributor to Feminist Judgment's Rewritten Opinions of the United States Supreme Court. In 2019, Teri was awarded the 2018 Teresa Godwin Phelps Award for scholarships in legal communication for her article, The Rhetoric of Race, Redemption, and Will Contest: Inheritance as Reparations for John Grisham's Sycamore Row. Thank you so much for joining us. Our second panelist will be Kelley. Kira grew up in Vermont, and then after a few brief stints in Louisiana, New York City, and DC, she graduated from Vermont Law School in 2018 and now serves as president of the Vermont National Lawyers Guild, as well as a contract attorney for the Community Environmental Legal Defense Fund. Kira firmly believes that legality should never be equated to morality. Problems are always more systemic than we are encouraged to believe, and community building is the best way to start anything. Thank you so much for joining us. And our third panelist, Zamir Benton. Zamir is staff attorney for the criminal defense practice in the Legal Aid Society. He is also one of the representatives of the Black Attorneys of Legal Aid Caucus, which is an amalgamation of Black legal aid lawyers. He spent 4 years in the Bronx trial office and now works as a community justice attorney in Brooklyn, where he provides legal services and trainings to nonprofit organizations that do cure violence work. He is the author of Law and Order Without Justice, a case study of gravity knife legislation in New York City, which is a law review article published in CUNY Law Journal. He also has a second article that will be published in Howard Law Review later this year, and he recently co-presented just a few weeks ago on the Black Lives Matter at the Community Oriented Defense Conference held July 15, 2020. And additionally, Mr. Dan teaches the Evolution and Expression of Racism, which is a course in the Black and Latino Studies Department at Baruch College. And this fall, he will be teaching seminar at CUNY Law. Thank you so much for joining us. So we're going to go ahead and have Professor McMurtry-Chubb start off her presentation, and then we will have Kelley, and then Zamir Benton, and then audience questions. So thank you so much.
Thank you, Serena. It's a pleasure for me to join you all today. So what I want to talk about, I'm a legal academic, but I'm also a practicing attorney. I just finished a 2-year stint with the U.S. Commission on Civil Rights in the policy space. And as a legal academic, I'm really concerned with how we educate law students, because the research that I've done and in my 24 years of teaching, you can't get clean water from a dirty well, meaning that we can't keep producing lawyers in legal education to be hierarchical and produce inequities and then surprise when nothing changes in the legal system. So my remarks today are going to be extracted from my article, The Practical Implications of Unexamined Assumptions, which deals with how unexamined assumptions of law students in law school lead them to produce flawed legal arguments in the documents that they produce. So the research that I conducted was over the academic year 2012 to 2018. So this is a 6-year empirical research study. These were 6 unique case files in a required legal writing course. So I teach courses in legal writing, social justice lawyering, critical race theory, and critical race feminism. So all of the case files that I write in required legal writing courses are social justice oriented. So these 6 unique case files dealt with a variety of issues from racial discrimination to LGBTQ issues. And the case file that I'm going to focus on is about specifically race in the legal academy. So 6 unique case files over 6 years. The research set was 192 students and 576 papers. So Serena mentioned that I am a discourse and genre analyst. And what that means is that I study how people write in their various disciplines, one of the things that I study. And so the research methods that I used were discourse and genre analysis. So looking how new writers formulate arguments, the mistakes that they make that are technical, but also adding a piece in there about how they formulate thought and translate that into writing. How does that replicate inequities and discrimination? So 192 students, 576 papers, 6 years. The students were first semester 2Ls. So at the institution where I taught prior to UIC John Marshall, the students took legal writing 2, the second installment of legal writing, in the first semester of their 2L year. The majority of my students were white, and most were enrolled in constitutional law at the same time that they were in my class. All right. So the assignments that made up part of the research set were a motion brief draft, a motion brief final, and an appellate brief final draft. Okay, so let's talk about the case briefly. The case that I'm going to be talking to you about happened in fall of 2017. And my plaintiff was Xavier Benton versus the West Virginia State University Law School. So West Virginia has a state university, West Virginia has a law school, but West Virginia does not have a state university law school. It's completely fictional. But I wanted to set my case in West Virginia because it's overwhelmingly white, and I wanted to deal with legacy admissions policies and race. So the main gist of the problem was that was trying to explore whether a challenge to law school legacy admissions policy on the grounds that it created an impermissible unconstitutional racial quota and unconstitutional race conscious admissions for white students was a viable claim. So I'll tell you a little bit about my plaintiff. So one thing before I give you a brief synopsis is that I make up my case files from scratch, and they're actually case files. So they're like a litigation universe. They're not just fact patterns. So when I set my problem somewhere, I research the rental market, where my plaintiff is likely to go shopping, where they're likely to go eating, you know, where all the players, whether they're plaintiffs and defendants in the problem, what they're most likely to be doing. And so Xavier Benton is an African-American male. He is a biomedical engineer by training. He received his degree from Howard University, where he graduated in the top of his class. He had over a 3.8 GPA and about a 170 or 175 on his LSAT. So he was in the upper percentile of all the applicants in the year that he applied, but he was denied admission. As a land-based school, land grant school, West Virginia State University Law School has to accept the majority of its students from West Virginia. So as a default, the majority of those students are going to be white. And the students that are of color are primarily outside of the state. So Mr. Benton was not granted admission despite being in the upper percentile of students who were in the admissions pool for that year. The reason why I wrote this problem is because students have often come to me throughout the years, and especially students of color, and this happened to me when I was in law school as well, that often my place my right to be in law school was challenged. So my classmates would say, you took a seat from a qualified white applicant. And I was troubled that this was still happening with the students that I taught, that they would come to me and they would be in tears many times talking to me about how their white colleagues in law school talk to them about their right to be in the law school class. So I wanted to kind of flip the script a bit. And my plaintiff, Mr. Benton, sued the law school, claiming that a white student took his seat. Basically, he's saying that because you have legacy admissions, and this is a predominantly white state, that these are unconstitutional race-conscious admissions policies in violation of Bakke and its progeny. So let's talk a little bit about the unexamined assumptions that my students came in with. One was that white is a neutral racial category. The other unexamined assumption was that only non-white persons have a race. And the third unexamined assumption was that race equals diversity, which excludes white people. So 3 unexamined assumptions. White is a neutral racial category. Only non-white persons have a race, and race equals diversity, which excludes white people. So you might think, well, okay, Professor MC, they have these unexamined assumptions, but what does this have to do with the work that they will do as lawyers? Well, these unexamined assumptions cause them to make flawed legal arguments using the applicable legal precedent. So I'm going to give you these 3 examples. So for the first one, white is a neutral racial category. Students argue that legacy admissions are only about class status, not race. Despite me hitting them over the head, I mean, I created like 10 years of admissions data. When I say I created 10 years of admissions data, like I created 10 years of admissions data that hit them over the head, were broken down by percentages, and it showed across the board, overwhelmingly, the students getting in were white, and the legacy admits were getting in with far less credentials than Mr. Benton, who is a Black person, got in on. The second unexamined assumption, only white persons have a race, my students who were representing the university were arguing that because Mr. Benton is African-American, his race is subject to a strict scrutiny analysis. Well, Mr. Benton is not the bad actor in this situation. The university is, and the university's admissions policy is subject to strict scrutiny analysis. So I want you to get the connection there, that the students were misunderstanding, or their unexamined assumption was causing them to make the argument that because only non-white persons have a race, Mr. Benton, who's the only non-white person in this problem, must be the subject of the strict scrutiny analysis, not the race-conscious admissions policy that favored white students. And then last but not least, race automatically equals diversity, regardless of the university's stated goals in using it. Well, the admissions data that the students were given emphasize that the stated goals of legacy admissions were to increase alumni donors and preserve the core values of the university. So it had nothing to do with diversity. So I employ a number of critical pedagogical methods, critical teaching methods to help students to disrupt these unexamined assumptions. But in the interest of time, I just want to share with you the results of my research. So remember, each case file was different. I still used the genre analysis as a research method, as well as the colorblind research analysis test, which measures how much students have a limited awareness of white privilege and how institutional discrimination functions. These were my 2 guiding research tools. So remember, I told you there were 3 assignments. So for this particular problem, for the first draft motion brief, 75% of students demonstrated a limited awareness of white privilege and how institutional discrimination functions. These results were true across racial lines. So it didn't matter if the students were of color or not, 75%, which is the majority of the class, demonstrated a limited awareness of white privilege and how institutional discrimination functions. In the second assignment, their final motion brief, that number reduced to 32%. And by the time students turned in their final appellate brief for the same legal universe, that number had dropped to 11%. So again, with critical pedagogical methods, I was able to disrupt students' unexamined assumptions and reveal to them the flawed legal arguments that they were making because of them. So what did I learn from this? Aside from this being a terrifying study, right? Because clearly, students are replicating hierarchies in how they learn about the law and how they think through legal processes. This is terrifying because the legal canon hasn't changed in over, since 1896. Basically, we're being taught the same classes and the same way to think. And so essentially, this is a significant research project, right? 6 years, 500 plus papers, 192 students. And what we've learned is that if we do make critical interventions at the law school level by employing critical pedagogy and by integrating social justice disruption into the law school curriculum, then into core classes, more importantly, that this will disrupt unexamined assumptions that students make and help them to be more socially conscious attorneys. So the main takeaway here is that we're trying to fix the problem on the back end with interventions in the justice system, but we haven't really changed how law students are taught to think, which impacts how they practice law. And that something that seems so innocuous as writing a brief is not innocuous at all. That many times lawyers are putting layers on top of what the law says and making damaging arguments with respect to their clients or damaging arguments that don't serve the cause of justice. So with that, I will turn it over to Kira.
Thank you so much for that. So I'm Kira, and I'm really just like appreciating being on this panel and getting to hear from other people too who are just like doing such incredible work. So I feel definitely underqualified. Also want to acknowledge the fact you can probably tell I'm white, so everything that I'm saying about race and racism like is not coming from personal experience, and that's something that's really important to acknowledge. Like the work of Black organizers, Black lawyers, racial justice advocates who are affected community and have this personal knowledge. Just like want to honor that, and I want to cite them as much as possible. And so please don't like quote me or attribute me with anything. This is coming from incredible like people who have done this work for centuries. And I think especially in this time now, we're seeing like an uprising around racial justice. And for a lot of people, specifically white people, having this like, oh my gosh, let's talk about these issues that we're just learning about, and recognizing we are stepping into like a really rich history of organizing that's been happening for a while. Like none of this is new. And that's like important to think about too as law students when we learn about the law and how unjust the law is. And it's been that way really since its inception. So I am really excited to be here. I run the Vermont chapter of the National Lawyers Guild, which is an explicitly abolitionist, anti-racist organization. We are a bar association of movement lawyers, legal workers, and law students. And we have this critical analysis of the law, that it is a tool that is rooted in white supremacy. The Constitution was written by a bunch of old white men who wanted to protect property rights over human rights. The environment is not even considered something worth mentioning in the Constitution. And so it's a tool that we can use, but I wouldn't say that it is something to be reverent of for its own sake. And that's kind of the stance that the National Lawyers Guild takes too, is that the law is something that should be used, and legal privilege is something that we should be opening up access to the movement. So trying to make the law as accessible as possible to affected communities who are on the ground doing movement work, and trying to fundamentally restructure something that is inherently rooted in racism and white supremacy. I'm also have been involved in like a lot of the work that the Guild does with the Anti-Racist Committee. The co-chair in that committee is predominantly white people who are trying to make sure that we are not just putting the work of ending white supremacy, which affects and harms everyone, on the shoulders of the people who are most acutely affected. So taking leadership from affected community, taking our cues and our direction from the people most affected by the problem, but also just trying to say, hey, like white people, we should be stepping up and trying to do as much of the grunt work as possible, because, you know, it's not about like doing this out of guilt or obligation, but really just like collective liberation means that we're all tied together. So this has to be really like what we're all doing. And I really like aspire to be a movement lawyer and to really dig into what that means. So my assigned topics today was civic engagement and protesting, and I'm going to try to say those words at least 3 times, so I like can stick to hopefully speaking to those topics, but I might deviate a little bit. And what I really want to cover is civic engagement, this concept that I like to call the box of allowable activism. That's and then talking about protests briefly, and then what it does mean to be a movement lawyer, because I think we're talking to a lot of law students, and law school for some of us is hard when you look at the law critically. So I just like want to name that, and I want to appreciate all of you for being here and for listening to this and for thinking critically about an institution that a lot of society tells us to have this kind of reverence for, even though we might look at it and see a lot of what it does as being really harmful. So civic engagement, I like to think of it as an obligation to not just navigate a really unethical system as ethically as possible, but to actually try to see how we can change that system. So it's more than just doing our best to be not damaging when we live in a system that's fundamentally racist. And this is, Angela Davis has this quote that it's not enough to just not be racist. You have to be actively anti-racist for anything to change. And that, I think, is especially true for white people, and especially true for Vermont. We see a lot of like Black Lives Matter signs in Vermont, and it's not just about the yard sign. It's about tracing racism and tracing violence to its roots and finding those roots and uprooting them, and not just saying I am no longer racist, because that's not going to undo the like centuries of racism that is just baked into our law. And even recognizing that laws don't have to be overtly racist in order to have a deeply disparate racial impact. And we can look at Vermont, for example. We have 1% of the population is Black, but 9% of the prison population in Vermont are Black people. And where does that come from? It is not as though laws are explicitly targeting people based on race, but every time there's discretion in when a police has discretion over who to pull over, when a judge has discretion for how to sentence somebody, when a prosecutor has discretion over what charge to bring. Discretion is this window in government where people's interpersonal racism gets to come in and have this huge systemic effect. So civic engagement would be going beyond just saying, okay, I'm going to make sure that I tread as lightly as possible on this earth or in this landscape, but actually being like, how can I change the system so that we're not set up to just keep propping up oppression? I think another example of the ways that like racism has gone beyond something that's just written explicitly into the law, but is just insidiously baked into everything from the way that our healthcare policies are structured to the lasting effects of redlining to like just where people are physically located. COVID-19, we just see how disproportionately this virus has been affecting people of color and Black people in particular. And that's not, the virus does not see race, because we know race is actually like a social construct that was meant to, create a class of people for which capitalism could exploit and extract labor from and be violent towards. The coronavirus does not see a social construct, and yet we see its incredibly disparate effect on people of color. And that's just a evidence of the ways that racism has been just so ingrained into everything that we see around us. So I want to talk about this concept called the box of allowable activism. And just to say that what I mean by that is that society and people in power and the people who are in power who benefit from oppressing everyone, and specifically oppressing people of color, oppressing poor people, oppressing queer people, gender nonconforming people, oppressing women. This oppression is beneficial to people in power with concentrated power. And so those people will devise tools, and they will give the tools to the masses and say, here's a way that you can create social change. But those tools are deliberately ineffective, or deliberately just effective enough that you might think, oh, I need to keep doing this. Like, this is what I must do because it's working just a little bit. It's like using a toothbrush to scrub, 6 feet of mud off the floor when maybe you could be looking for a shovel or looking to block the hole where the mud is coming from, so that you're not just, doing exactly what the system has done to create a mechanism for change for you that really just keeps you busy. So I guess to give like an example of that too, and I should stop by saying there's a lot of ways that white supremacy shows up that are not explicitly racist, and that's like the way that white supremacy has like kind of colonized our minds to make us think in terms that prop up white supremacy without explicitly being about race. And so one of those is the way that like we think either or, like it has to be this or it has to be that, like black and white thinking, kind of creating a binary out of everything, or being a perfectionist about something, or fixating too much on tangible results. All of these are insidious ways that white supremacy programs us to like not build community or to not move towards collective liberation. This like fixation on having quantifiable benefits. So we're like, we're nervous to put down things that we know work, even if we only know they work a little bit, in order to look for maybe the unknown. And that's why I think like we can't emphasize enough community building, because that's something you don't have a visible benefit, but really does like have these really just like intangible cascading effects that we kind of can't quite see. So looking for tools that society kind of gives us. And I guess to give you an example, in Vermont in 2019, in March, a lot of you might know this, Act 1 was passed, which was the Ethnic Studies Bill. And we have this, with this huge problem in schools where like history is taught from a white male gaze. Like we learn about Christopher Columbus, we learn about like everything is like kind of like we were hearing about in the last panel, like white is not seen as a race, it is seen as the default. And that's like echoed in our whole curriculum. That's just like reprogramming racism into people, even insidiously. So this ethnic studies bill was passed to try to get curriculums to have more books by Black authors, to have more books where like disability is normalized, and like where authors can be queer, or like, learning from a perspective that is not just the one that we've always been taught, which is really problematic. And this bill came and it got passed, but there's no funding behind it. And what it did was it created a working group to then like create a bunch of recommendations. So like kind of drawing on all this labor from affected community and really soliciting input from people who like, know their stuff and like have great ideas. But then in the end, the Department of Education is left, the bill recommends that they consider the results of the working group. And so I want to say like, the people who push for this bill have been working so hard, and it's like incredible to see that that momentum and that push happening, but also to name that the bill is still leaving it up to a couple people in power to decide whether or not to undo just like generations of white supremacy programming in our schools. So it's like a tricky thing, because we're kind of still leaving it up to a fundamentally white supremacist institution to decide like the terms of how much and how far it works that back, and how much and how far it deprograms that. And then that's kind of like typical for a lot of areas of the law that I think we can see. So I want to talk about protests and power as the not necessarily alternative to that, because I think there's immense value in mass mobilizations, in legislative change. Not trying to say that we shouldn't be doing that, but just trying to say, let's do as many things as possible and think critically about what's effective or what's not effective. I would define a protest as people begging those who have power over them to like please use their power differently. That's like when we go to the state house and we hold up a sign that says defund the police. We're saying, please use your power to lessen the oppression that we're facing. And that's like really great for getting a message out, but that's not necessarily always what makes people in power shift, that sign holding. And then contrasting that with something like direct action, which is where you use like your own power to try to make the change that you want to see in your society. So that would be maybe something like actually creating education that centers Black history and the stories that we've never really been told, by having teachers just go ahead and teach that, like not waiting for the people in power to make that okay, just going ahead and doing it. And then the third thing being civil disobedience. And this like comes from like, the civil rights movement has such an incredible history of doing this. Like this civil disobedience is the performative breaking of an unjust rule or law. So sit-ins were civil disobedience because they performatively broke unjust segregation laws, and also kind of direct action too, because they directly created a segregated environment in the face of a society that was trying to separate people through these unjust laws. So using a combination of these three and really celebrating diversity of tactics, but understanding as lawyers, if you're, aspiring movement lawyers, trying to make sure that you are like supporting your clients in whichever tactics that they want to do. And then as humans, like living in this world, all legalities aside, just like really thinking about the difference between what's legal and what's illegal, and what's moral and what's immoral, and wanting to make sure that we're not just kind of abdicating our moral compass to the law, because a lot of times there are things that are legal that are totally wrong, and there are things that are illegal that are completely morally right. We can look at immigration as a whole body of law where there are things that are legal that really shouldn't be, ripping people from their homes and their communities. The whole immigration scheme is kind of just like legalized racism. If you think about it, like who gets caught, like, or who gets targeted, who gets profiled. It's not the Canadians, white Canadians. It's not white Europeans coming over here that have the hardest time. Like this is just kind of legalizing racism. And so just like always asking what the goal is, and asking your clients what the goal is. I think that's like just getting into movement lawyering a bit as the fourth thing I was going to talk about. Emphasizing that is always more important than legality. And I'm not telling anybody to break the law or telling you to tell your clients to break the law, just to like be critical of our inherent reverence for the law, really, as attorneys especially. And also to like remember when you are a lawyer in an activist situation, like you're inherently going to be a little bit disconnected from the problem because of your privilege. And especially like, I'm going to just like talk to the white lawyers. Like I'm a white lawyer. If I go into a meeting and I like tell people I'm a lawyer, they're going to give my words more weight, even though I don't have the personal experience that like we should be honoring in that. And that's like another tenet of white supremacy, is that we honor academic privilege more than we honor personal experience. So like recognizing that our privilege like kind of inherently separates us from a lot of that personal experience. And especially as white people, like when we're doing movement, making sure to ground ourselves in like the trust and experience, and like the movement lawyering experience means like the organizers are the experts, like affected community are the experts, and you're there to figure out how to support them, how to make that happen. So that kind of like covers a lot of the just like broad brush theory behind, I think, what it means for me, at least, to be like doing this work, and for the National Lawyers Guild, like really just trying to say what works, how can we support what's most effective, and to try to not get caught up in the things that we're told are effective, but maybe aren't necessarily like the deliberately ineffective tools that society gives us. And I think, if you want an example of that, we can look at like the Clean Water Act. And I know this might be blasphemy speaking at a school that's really big on environmental law. But I came into Vermont Law School wanting to do like the Clean Water Act and maybe even working for the EPA, but realizing that because of the corruption in government that we're never really allowed to say no to projects. We're just allowed to say how much pollution we're willing to accept. And that's often at the negotiating table that was designed by industries. Like industries write these regulations and pass them over to the regulatory agencies who then sign them. So we're kind of entering the scene, negotiating on a table that's already been set by people who are okay with losing to us on the terms that they've like defined as a loss. And so often with the EPA, we can just say where the pollution goes, which is like communities who have the least amount of resources to fight that pollution. And so where is that? Like, and that's because of like the systemic tie between poverty and racism. That's why we have environmental racism, where kind of privilege gets to dictate where clean water is and where it isn't. And looking at the Clean Water Act as maybe not necessarily the best use of resources, but rather addressing the system as a whole and thinking like, how can we give the choice to the people who are most affected by the decision to make that decision? So that's all I have to say, and I'm excited to hear from the rest of you. And thanks for having me here.
All right, so good evening, everybody. I'm very happy to be here, and I'm thankful to the organizers for inviting me. So, in speaking about deconstructing race in a legal career, a couple things I just wanted to make clear. Number one, in terms of fighting against racism, I think one thing that we all need to be clear on is the fact that it is not easy, it is not fun, it is not comfortable, and it is not quick. Um, Particularly in light of what has gone on in terms of the police brutality protests and George Floyd being killed and all of the other individuals who were killed by police. There's been this big push of people talking about anti-racism and reading anti-racism books. But the thing that needs to be understood is that it's not something that you try hard for 5 minutes and then you're done. This is a constant struggle, and it's a struggle in which you're going to be tested, in which people are going to be made uncomfortable, in which you're going to ruffle feathers. That's just the reality. In terms of dismantling racism beyond that, I think there's certain things that need to be understood. So, of course, you can't deal with a problem if you don't know how the problem operates or what exactly it means. If you're talking about deconstructing racism and dealing with racism, you have to understand what racism is and understanding that it is something systemic and not something that simply is limited to individuals. It's important to understand the history of racism in the United States of America because you have to know the past in order to understand the present and ultimately plan for the future. I think all too often people attempt to analyze problems that pertain to race without any discussion whatsoever about what occurred in America's past. And one thing that I personally have found very lacking in anti-bias trainings, particularly with respect to their analysis on racism, is that there's just this conversation of white supremacy and conversation of white privilege, and there is no context laid. And that context needs to be laid so that people can understand where we're coming from when we talk about white supremacy, when we talk about white privilege. And it's also important because you get a sense of how racism operates today. Nowadays, people are not walking around saying racial slurs. People are not walking around saying things that are blatantly racist by any standard or that will be obvious to any person, regardless of how ignorant that they might be. Um, but when you examine history, you see that overt racism pretty much became a thing of the past from the late 1960s. And from the 1970s, you start having coded racism, you start having covert racism that is in essence endorsed by the Supreme Court, because now in order to prove racial discrimination at the Supreme Court level, you need intent, and disparate impact is not enough. So as long as somebody does not openly say that they're discriminating against people on the basis of race, then they can get away with it as far as the Supreme Court is concerned. And it's important to understand that because when we talk about racism in the judicial system, be it housing, family, criminal law, which is where I practice, racism is not going to come in the form of racial slurs being offered or in terms of plainly, blatantly, overtly racist comments being made. But it's going to come in the form of how people are perceived, how people are viewed, and how decisions are ultimately made. In terms of understanding racism or deconstructing racism, we have to understand how widespread it is. I think all too often people try to limit racism to certain pockets where we know that it exists in the criminal justice system. We know that it exists in policing, but perhaps not so much of a discussion about its existence in education or its existence in housing or its existence in the medical profession. Um, a lot of times there's conversations about, oh, how it exists and how Black men are targeted by the police, but not how Black women are targeted by the police or how Black LGBTQ are targeted by the police. And so a lot of times we try to limit just how widespread of a problem this is. And it is a major problem that goes beyond just the criminal justice system or the legal system as a whole. And it has to be examined as a problem that goes beyond that because the legal system doesn't exist in a vacuum. It exists in context with other systems of oppression in education, in housing, and so on and so forth. I'll give you a very easy example. Let's talk about the media. How does the media portray people of color in this country? It has always done a terrible job. And yet people watch the media, people watch the news, people watch television, people view the internet, and their minds are being conditioned as to how people of color allegedly operate. And so in this country, Black and brown people, in the eyes of many people, including people who are judicial practitioners or practitioners in the legal profession are not viewed as human. They're viewed as irresponsible. They're viewed as prone to criminal activity. That's a big one amongst people of color in the criminal justice system for sure. They're viewed as sexually promiscuous and lascivious. And so when you have these perceptions that are being attached to individuals who wind up being involved in the judicial system, then it's not too difficult to see why judges have such terrible rulings, why prosecutors are completely indifferent when it comes to the lives of human beings, why landlords don't care, and so on and so forth. And then in terms of deconstructing race, of course, within the legal profession, it's important to understand how it manifests itself. And so it manifests itself in different ways. I'm just going to give a few examples given the time. It manifests itself in terms of judicial deference, in terms of factual determination. So a lot of times when judges are making decisions about facts, what happened in a given case, be it in a family court case, in a housing court case, in a criminal court case, when we're talking about suppressions and evidentiary hearings, the judges are going to be the ones making the facts. Now, in terms of deciding what the facts are, you have to decide who to believe. And so who do you believe when you have a landlord versus a tenant, where the landlord is white and the tenant is a person of color? Who do you believe when it's a cop versus a person of color? A lot of times, because of how they've been trained to view people who are people of color, who tend to be tenants in housing court, who tend to be people in family court, who tend to be clients in criminal court, a lot of times they're not going to view things in a manner that is favorable to them, even if they might be telling the truth. And landlords know this, police officers know this, people who are in positions of power who come to court and accuse people of color of things, or are adversaries to people of color in the judicial system, know of this, and they exploit it to the maximum advantage. In terms of statutes, in playing language games, as lawyers, we're trained to play around with words and to think of how we're going to make arguments and how we're going to structure certain arguments. A lot of times the law is about terminologies, technicalities, and definitions. And I've always liked to use this example when I talk to people, where I say, I can turn around and say that I've abolished solitary confinement. Let's say I was the warden of a jail. And I can say, well, I've abolished solitary confinement, and solitary confinement no longer exists. Now, solitary confinement may have a very particular definition. Solitary confinement means that you've been locked down for 23 hours. So if I lock people down for 22.5, that's not solitary confinement because it's not 23. And so we can play games in terms of how we interpret language, in terms of how we interpret paragraphs, how we interpret statutes, and so on and so forth. And so I can give an example with regards to a recent bail law that was passed in New York, where under certain circumstances, a person who commits a crime that involves a quote unquote identifiable harm to person or property, bail can be set on that particular individual. Now, I think for most of us, when we read identifiable harm to a person or property, we mean that somebody got hurt or property got damaged. I mean, that just seems to be plain old common sense. But very recently, a judge turned around and applied that law to set bail on somebody who was charged with stealing food from a store. Now, the way I see it, this is clearly not harm to a person or property, but as far as they're interpreting it, well, it was harm to the owner, to the property, to the owner of the store, because it harmed the store because the person stole food. And so how the law gets interpreted, where you interpret it in certain ways that are detrimental for the client if the client is black or brown, and you interpret it in ways that are beneficial for the client if the client so happens to be white. Another way in which it manifests itself is through the use of discretion. Discretion is a really, really big one, because when it comes to the discretionary decisions that are made by judges, they're very, very hard to appeal. The abuse of discretion standard is extremely high, and for the most part, it's pretty much difficult to get around it. Judicial discretion is most prevalent in family court when it comes to decisions that are made about alimony, decisions that are made about child custody, the decisions that are made about child support, and other decisions along those lines, where the judge pretty much, for the most part, has free reign to decide what they're going to do. And a lot of these decisions are based on very primitive attitudes of the people of color who ultimately come before them, assuming that the clients are people of color. When it comes to criminal court, we see examples of discretion as well. One clear-cut example is with bail, particularly in jurisdictions where bail is used for more than just ensuring the return of somebody to court. For the longest time in America's history, that was the purpose of bail. Now, all of a sudden, bail is being used to detain people who might be dangerous. And who do you think that's likely to be? Who's likely to be presumed dangerous? Who is viewed as dangerous? When people think of a dangerous individual, a lot of the times it's people of color, black people, brown people who are viewed as dangerous individuals and who are more likely to be detained pre-trial. And that's actually what the statistics do, in fact, bear out. And then decisions with regards to trial mechanics. So the judge can limit, for example, how jury selection is done. And depending on whether or not the judge likes your client or the judge doesn't like your client based on whatever the factors are, making jury selection more difficult, controlling cross-examination, controlling different aspects of the trial, controlling what evidence is allowed in and what evidence is not allowed in. A lot of times these decisions are made off of factors that they should not be made off of because they are in fact racist in nature. And then in terms of prosecutorial discretion, I'm focusing on that because that's probably one of the few arenas in the legal system where the opponent is, in fact, a branch of the government, the prosecution being a branch of the government. And so there is prosecution discretion in terms of deciding whether or not to charge a person, what to charge, and what offers to make in a given case. And I have personally seen where, when we're talking about white clients, that prosecutors will make more generous offers than if we're talking about black and brown clients, where prosecutors will be more inclined to dismiss cases because it's a white client, and white clients simply come across as more sympathetic, allegedly, than black and brown clients. And so we see that in terms of the discretion that they have and the power that prosecutors have, where they can drag cases out or they can rush cases forward. And a lot of times when it comes to black and brown clients, they will drag cases out, particularly if there are other things at stake. So having a case that's dragged on for a particular period of time can impact employment, because there are certain cases where you can't work unless your case is resolved. It can impact the recovery of property, where you had your phone seized, you had money seized, you had property seized that you need, and you can't get it back until the case is done, if you can get it back at all. Immigration status, of course, having an open case can be dangerous, especially during these times, although immigration law is always particularly bad. And then the most obvious one being your liberty, right? If you're sitting in jail on bail that you can't make, or you're remanded, and cases are dragging on, then that's more time that you're sitting in jail. And these are decisions and these are actions that ultimately disparately impact black and brown people, impacting people of color. And then just to talk about interaction amongst lawyers, because there are a lot of attorneys who go into public interest work in particular, who seem to think that because they went into public interest work that they are free of the effects of racism. Racism is a centuries old system of oppression. And the idea that you can erase the effects of a centuries old system of oppression simply by joining a profession is illogical and just doesn't make sense. And of course, if you're of that mindset, then there isn't much room to grow. And so there's that belief in terms of people thinking that they can't be racist. How individuals deal with their black or brown clients, how public interest attorneys deal with their black or brown clients. In terms of providing deficient representation, I have definitely seen that. Um, I remember not too long ago, it was about 2, 3 years ago, um, there was an attorney who got up and during a bail argument, and he called his client stupid about 10, 11, 12 more 12 times in the entire bail argument that he was making, calling his own client stupid. And that wasn't even the worst part. The worst part was that he then went on to argue that because it was a rape case where the client was charged with statutory rape, and he said that his client was under the reasonable belief that the person was above the age and there was no force, it was consensual sex. Now, anybody who studied criminal law knows that when it comes to statutory rape, there is no age defense or mistake of age defense when it comes to statutory rape. If the act is proven, then you're guilty. It's a strict liability crime. And so providing deficient representation, in part because he didn't know the law, but in part because he had no respect for his client. Addressing clients like children. I see this all the time of public defenders or housing attorneys or family court attorneys talking to grown men and women like their children. Part of that is stemmed in this idea that their clients are irresponsible based on their appearance. Speaking about clients in racially insensitive ways. So I've seen that in the office where you talk about this particular client because this client didn't take a disposition that you thought was good for them. And the way that the client is spoken about in the office, you can almost replace client with the N-word or with some other racial slur, and the conversation would in essence sound the same. And then, of course, the treatment of colleagues. Of course, we can talk about microaggressions and macroaggressions in the workplace all the time because, in fact, they do happen. When we're talking about racism, we're talking about a system. So disparate treatment, disparate opportunities, and disparate promotions, in terms of people of color not getting the opportunities that their white colleagues have gotten, or perhaps don't even know about those opportunities. Questioning ability, wondering whether or not your black or brown colleagues know what they're doing, or whether they're qualified in the work, asking questions or saying things that suggest that. Viewing black people improperly. I know in my office in particular, and I'm sure it's not specific to my office, but I have definitely heard stories from some of my black female colleagues about how they will be approached by white men who do not view them as colleagues, but instead view them as potential bed partners or hopeful bed partners, which of course that wouldn't happen. But the whole idea of not recognizing their black or women colleagues as capable colleagues, worthy of respect and worthy of praise. And then other micro and microaggressions as well. So in terms of what to do about it, I would say I think there's so many things that should be done about it, but kind of some of the most central things that need to be done is just education. People need to be educated as to the four things that I talked about. So, what exactly racism is and what it isn't, understanding the racial history of the United States, understanding how widespread it is, that it's not something that is just limited to the legal profession, and it's not something that can only be tackled within the legal profession. It has to be tackled beyond that. And then understanding how it manifests in the legal profession. So, definitely educating yourself and educating those who are willing to learn. And I have to throw it out there in terms of willing to learn, because there are some people who just aren't. And that's just a fact that I think definitely needs to be dealt with. And then in terms of challenging it as it manifests in the judicial system, use your discretion. There are times where you should, there are times where you shouldn't, because of who exactly it is that you're dealing with. A lot of times, in my experience, judges try to act as if the legal system is this perfect system. And if you even mention the word racism, some of them go through the roof, because, you know, it just doesn't exist here. But there are times to challenge it, and there are times to say something about it, and I think it's appropriate. And then the last thing that I would say is become active outside of your legal profession job, because this is the problem that goes beyond the legal profession, like I said. The presenter before me talked about the importance of protesting and things like that, and that is, in fact, very much important. So while you are involved in the legal profession in terms of trying to make change in the legal profession, and in terms of bringing lawsuits where lawsuits should be brought, understand that the legal profession does have its limitations because of the origins of the system. The criminal justice system, especially, it was designed out of racism. It was designed out of the backlash of the end of slavery. And the whole prison system came out of exploiting the loophole that was created by the 13th Amendment. So, in terms of what to do, in terms of how to confront it, educate yourself and understand what exactly it is that you're dealing with and what exactly it is that you're fighting against, so that you could properly fight against it. And with that, I will conclude.
I want to thank all of our speakers. Thank you so much for sharing your time with us, sharing your expertise with us, and just being a wealth of knowledge as we try to tackle these larger issues on our law school campus and also within our community. So thank you so much. Now we're going to shift over to our Q&A session. And I want to remind everyone watching, there's two ways you can comment your question. On Facebook live stream, you can post a comment, as well as on the BLS website. There is a comment icon in the top right corner, and it'll open up a comment box. You can also comment there. And we're going to get questions rolling. So the first question I have is for Professor MC. This person writes, some states have started implicit bias training for state attorneys and interns. Med schools also recently required sociology and psychology as an entry requirement for the MCAT. My question is, should we be performing implicit bias training with professors so that they can provide critical intervention? Same for student requirements, because class discussions can be sensitive. And
Well,
they had
I
a
also,
point of,
go ahead, Serena, I'm sorry.
oh no, I'm sorry. I'm reading now. They had a point of clarification. They said, I asked this because some scholars have raised serious privacy concerns with this kind of policy concerning disclosure of bias tests and training outcomes impacting employment decisions and things like that.
So I answered this question with someone who has been a diversity, equity, and inclusion consultant for over 10 years now. And doing that work for various institutions over the time I've been doing it, as well as being the critical race scholar, implicit bias training, this is controversial, it doesn't work. It doesn't work in the way that people expect it to work, because one-off training cannot erase white supremacy, patriarchy, capitalism, and imperialism. And so the institution itself has to have a commitment to directly challenging those things and structurally making changes in order to move the institution forward. So the question, as I'm looking at it, they're saying, linking implicit bias with critical interventions. And implicit bias training is not teaching anyone at the training critical interventions, essentially. It's teaching people how to be more aware of their own biases. But I found, especially since 2016, that implicit bias is not implicit anymore. It's explicit, that people are less likely to be concerned about the kinds of things that they say, and who they're likely to offend. So I think the gloves are off. So as a requirement, I don't think it's effective. Also, there is privilege in the way that people ask for the training. Let me clarify. So as a student, you might think, okay, I need some problematic things happening in the classroom, and I want my professors to be held to account, and I want to give them some type of tools in order to navigate difficult conversations. And that's laudable, but understand that for faculty of color, we are thrown into classroom environments where we are consistently, throughout our entire careers, dealing with implicit bias, explicit bias, microaggressions, and nobody is offering us any training for how to navigate white supremacy, patriarchy, capitalism, and imperialism as it shows up in the settler colonialism of the university. So when you say this, you're basically saying, let me help my white professors to navigate the racial landscape, but we have to sit through that, right? And so you need to be specific, because as Kira was saying earlier, our life experience, like, we don't need to sit there and learn about, oh, this is a microaggression, because we just experienced it when we walked into the training. So I think that that's, an issue to really think about and what you're asking for. What you can ask for, though, is to give professors specific tools about how to directly interrogate and challenge white supremacy as it exists in the curriculum. And you can ask your administrators for that too. And what does that mean particularly? It means that when we are teaching the legal canon, that there are certain cases that have, since we've been teaching the canon and people of color have entered law school, have been problematic, because professors don't engage with the racial issues in the class. And I can start naming them, and I'm likely to get a smile from both Kara and Zamir if I keep naming them. So Williams v. Walker Thomas Furniture, Johnson v. McIntosh, State v. Getz. I mean, these are cases that I told you. These are cases that if the professor is not equipped to take on these issues, then you have students of color who are sitting in class pissed off because they're like, are you frigging kidding me? Like, we can talk about, reasonable man standards and Bernard Getz, but we're not talking about how that's informed by white supremacy and this perception that young black men are dangerous, right? And so, so the professors have to be taught and held to account to deal with the issues as they pop up in cases. Like, I've been at institutions where I've had constitutional law professors say, you know what, we're going to talk about the 3/5 compromise, but we're not going to talk about slavery. How is that even possible, right? And so there needs to be some kind of accountability at the administrative level, where someone's saying that's not acceptable in a constitutional law class. You will talk about slavery. You will talk about the context for these classes. So I think that has to happen. With respect to, disclosure of bias tests, training outcomes impacting employment decisions, I've not seen that happen, quite frankly, because people, again, at implicit bias trainings, it's all everybody's kind of walking on eggshells because we got the training, right? Like, people of color are secretly overjoyed that there's something to to support what they've been saying all along. And so they're just happy that there's training there, but we don't have any, for the most part, faith that this training is going to miraculously change people into anti-racist activists, right? So no one's looking at the results of bias tests and saying to professors or anybody or any lawyers at law firms, even this work that, we've done at law firms, nobody's saying to practicing lawyers, oh, well, you scored really low on the IAT, so we're going to have to really look at the bonus structure for how you're being rewarded at the law firm. That's never going to happen. And so, again, you need to be really specific about what you're asking for at your specific institution and identifying those people who can do them. The last thing that I'll say about that is that it is important, as both Kara and Zamir said, to make sure that you've got a well-rounded group of people coming to your campus. So it can't just be academics, it can't just be activists, it can't just be practicing attorneys, but it has to be all of us working together and not superimposing what we think a community needs on that community, but really listening to what the people in the community want from the community, whether that be an educational institution, a Fortune 500 company, a law firm, or a nonprofit organization.
Thank you so much for your comments there. And I want to invite everyone watching once again. This is an opportunity for the student body and really all viewers to ask your questions, to really be deliberate and kind of voice some of the things that you're thinking about in a respectful way, of course, because we want to make sure we give everybody the chance to really think about these issues critically and kind of get some insight from our panelists here. So ask your questions. We have one. I'm going to go straight to the next one. And this is an open question for all three of our panelists. Moving forward, what is something that we as law students can do to be effective change makers? It's a tough one.
The question is what can we do as law students to be effective change makers?
Yes. Mm-hmm.
Okay. I'll take a stab at this one. It's a good question. I would go back to, I think, some of what I said in the end of like educating yourself and recognizing the scope of the problem that you're trying to solve, whatever the problem is. I would also say recognizing, this might sound controversial, but recognizing the limitations that the legal system has. Like, change is not going to be brought about solely through legal action. And depending on which systems that we're talking about, like if we're talking about the criminal justice system, the amount of change you're going to bring about is pretty close to zero. And that's not to say that you can't, being a lawyer in the criminal justice system is not insignificant. Like it needs race conscious attorneys to make a difference in the lives of the people who get entrapped in it. And people are going to get entrapped in it even as people are on the outside fighting it. So it's important to have that race consciousness, but it's also important to understand that the legal system was not erected as a means for structural change. It doesn't exist for that purpose. Law in this society generally has not existed for that purpose. And so you fight how you can in the legal system, in whatever work you're going to do. If you're going to do housing, you fight the evictions to the best you can. If you're going to do criminal, you fight for your clients the best you can. If you're doing family, you fight against whatever decisions that the judge is trying to impose. You fight to the best that you can, but you recognize that the legal system is not the be all and the end all, and that you're going to be organizing from outside, whether you're taking the legislative route, whether you're talking about taking to the streets, whatever the case is. Just recognize that it has to be a multifaceted approach, and you cannot be tied to the legal system as your only vehicle for change.
Professor, I think you're on mute.
I was, sorry. I would also echo what Zamir said earlier, which is that you're fighting for, this process is not quick. So understand that you might be fighting for changes that you will never, ever see in your lifetime, because people that came before us fought for things for us that they never got to see. And so it's important that if you are doing social justice work, that you're playing the long game, that you understand that you are part of a movement that doesn't begin with you and it doesn't end with you.
I think another thing that Zamir said that's really true is like, we are not the ones that are like, and I hope I'm not putting words in your mouth, Zamir, but like what I heard from that is like, lawyers are not the ones that are making change. Like when like these Supreme Court cases that get decided, like clarify new legal things that like end oppression in a certain way, it's because of like the like incredible amounts of efforts that organizers have done. That then the lawyers kind of solidify the change, but we're not actually the ones that are like doing this. So I think like, if you're looking to be a change maker and you're a lawyer, like for me, what I have found to be the most effective is just like being as generous as I possibly can with giving free legal support to grassroots groups, because like so often these groups are on like shoestring budgets. They are like really in touch with the problems. They're really in touch with solutions, and they just need like an hour or two to talk with a lawyer about like this, that, or the other. And just being able to be that resource for them, like to cue off of them in what they're telling you they want and what they're telling you they need, and to just be that, like, be a tool for the movement, really, just like, and be as generous as possible. I mean, especially like for white people, like, if we believe in reparations, which I hope we do, like, let's start right now. Like, we should be doing free legal work for Black-led movements and not trying to come in and be a savior, but really just trying to be like, let's work together. Like, let's figure out, because, this is like a horrible system. This is like racial capitalism. We're all being oppressed by this. And like, we have experts, and those are the people on the ground. So just like kind of a little bit goes a long way if you can just like what people are already doing.
Thank you so much. We have one more question here. This is also an open question for all three of our panelists here. How do we encourage teachers/professors to include more diverse perspectives if that material isn't on the test?
Why isn't it on the test? Would be my question. But, more seriously, I mean, I was totally serious. But again, I think that, what Kira and Zamir are saying about activism is how I look at it, is that everyone marching on the street gives me leverage to negotiate at the tables where I'm at, right? So I could say, hey, the students want this. And if we don't do this, this is what the consequences are. It's not like a gun to our head, but it's like, we're here to provide you with an education over 3 years, and you should have some say about what that looks like. And it shouldn't have to always come from students to have representation in the curriculum, but it helps your faculty who are advocating for that, for students to be vocal. So for instance, recently after George Floyd and Breonna Taylor, we had a number of our student groups, and Ahmaud Arbery, we had a number of our student groups our student affinity groups write letters to the administration in support of Black Lives Matter, but also calling for specific things that they wanted to change. So for instance, the National Lawyers Guild, and I'm a co-faculty advisor of the National Lawyers Guild. I love the National Lawyers Guild. You guys are radical. They said, look, we want prison abolition to be taught in all criminal law courses, period. And called for faculty accountability. What are you doing if you teach criminal law to talk about prison abolition? They also said, we want no police presence, zero police presence in our law school. So when you have police officers in the law school, it triggers people, it's threatening. We don't want them using our restrooms. We don't want them using our space. That's what we call for. So I think it's useful then as faculty to be like, well, how are we going to integrate abolition into our courses? Because clearly the students want this. And so you had BALSA, NALSA, NAPALSA, all affinity groups saying, you know, Balsa wrote a main statement, the affinity group signed on and said, okay, we support what Balsa wants. Balsa issued, you know, kinds of things that they wanted, but were very specific in terms of, you know, what they wanted to change curricularly, what they wanted to change with student services. And so those are specific. When you have concrete things, then you can begin to negotiate more effectively with the people who are delivering legal education. And that's not just in school, but that's everywhere. I think that the people with the power to make decisions can make those decisions or can negotiate better for your needs if you are doing the work of advocating for yourselves.
I agree with everything that Teri said. I would just add, in terms of, I guess, an additional angle. Like, the fact is, if you're tasked with educating people, you can't educate people if you're not adding context. You can't educate people if you're not talking history. You can't educate people just by throwing out things at random, statutes at random, case holdings at random, and then say you're educating people. Like, that's not a full education.
It's true.
I think too, like, just the first and foremost thing that can be done, even if we don't deviate from the curriculum, is like thinking about how we frame cases when we talk about them. And it's kind of similar to like how like political theory is implicit in how professors frame their opinions as truth when they talk about things in the cases, like talk about the reasoning and the justification and the context for the cases. And in the same way that like white people like don't see whiteness because like society trains everyone to see whiteness as normal, so do like people who are, you know, racist and capitalist and believe in the racism and capitalism that's baked into the law. They don't see it because that's perceived as normal. So for like something that I wish I saw more of in law school was professors who were willing to call out the, I'm going to just swear, I hope that's okay, like call out the bullshit when we have that in the law, and when we have these cases that are like trying to say that like we should be glorifying the case that upheld the Civil Rights Act, like the hotel case where like you had to like tie a person's like worth to commerce in order to say that like Black people deserve like equal treatment. Like that is like really dehumanizing and totally messed up. And so for that to be part of the framing of that case, like is important, like first and foremost, to have that critical analysis of the racism in the law that's in the cases that we already study. And then also like bringing in new subsects of the law and like bringing in more diverse perspectives with new cases. But like we can start with where we're at and like think about how we frame things too.
Thank you so much. And Kira, this question is related, and it's also directed towards you. This person writes, I intend to pursue my master's in restorative justice. My question is to Kira, why would white people want to fight for racial justice when it works for white people to use it to their will?
That's a really good question. Like, why should white people be involved in racial justice, or why are white people involved in racial justice? And like something to acknowledge is like, there's a lot of white people who are involved in racial justice for the wrong reasons, like because it makes them feel good, because like white savior complex, like because you know, we want like a platform, and that's like really messed up. There's ways to be authentic in it. Like there's a lot of really great resources that maybe, I don't know, my email is vermont@nlg.org. I can email you some resources if you want to email me this question, to kind of give you more to the source, like thinking about ways to be an accomplice rather than an ally, to recognize that like white supremacy does hurt white people too, and not as like, we're not like as violently and directly impacted, but like this system that is like, you know, both exploiting Black people and doing violence towards Black people is also like exploiting and doing violence to like any number of marginalized identities, and just like young people being the like affected community of climate change. Like we're all stuck in this, and we're all oppressed by the same system. And like we have so much to learn from the expertise of people that are like affected by it in different ways than us. So I think there's like maybe a lot of good answers too. And I would love to hear from Zamir and Professor M about like, you know, how you see this too, because I think it's really something you're gonna have to like decide for yourself too.
Professor, I believe you're on mute again.
Sorry about that. I've only ever worked at PWI institutions, so the majority of the students I educate are white. And so part of my work is to make white people invested in racial justice because we can't get there alone. We all have to get there together. And so I think educating people about about white supremacy, about patriarchy, about capitalism, about imperialism, about settler colonialism, and understanding how that frames every aspect of society and including their legal education is imperative to producing socially conscious lawyers, or lawyers that at least understand what tools they're using and what damage they can do and how these tools undermine the cause of justice. So we can't, we're not going to get there as separate groups, although we have separate needs and separate requirements. But this is an effort that requires all of us to work together to the extent that we can.
So the question, as I heard it, was why would white people want to fight for racial justice when it benefits them? Is that
Essentially, yep.
about right? Okay. I mean, I think all human beings just generally have ideas towards or aspirations towards fairness, justice, equality, and things like that. Um, and if we're going to achieve that as a society, then it requires recognizing the fact that you can't have systems at play that value some over others. So if they are truly for justice and equality and things like that, then there should not be an issue in terms of why they would be willing to fight for it. Even if the benefit is coming to them, if there is a benefit coming to some and not others, and that's not fair and that's not just, and if that's what you're fighting for, then you should be fighting for it.
Thank you so much. Our next question states, or they ask, what are your thoughts on schools asking people of color, BIPOC students, specifically Black students, to help create diversity policies?
I think it's
Okay,
wrong
so
to require it or to expect that the burden should be on Black students to fix the problems of institutional racism. That's wrong. But I think that Black students need to be at the table, but that the disproportionate burden should not be placed on Black students or any other students of color to create anti-racist policies, because they didn't create them. They didn't create racism. And so in addition to just navigating school and dealing with the macro and microaggressions day to day, it's exhausting. It's psychologically exhausting. And I don't think that there's, that we ever look at students of color and how they navigate law school and the exhaustion, the emotional trauma that occurs being in that space, and then asking them to engage in the additional invisible work that's not going to be rewarded to help an institution is not fair. So my short answer to the question is Black students should be at the table, and to the extent you want them to do the hard work of coming up with policies, you need to pay them. like folding money, not just, and maybe even scholarships too, but you need to pay them, because that labor should not be invisible and it should be compensated, because it really is labor.
yeah, I think the operative word there is help. If you're saying that they're helping to do it, then okay. Because I think in terms of creating diversity policies, the experiences of people of color should be part of that conversation. Oftentimes the experience is that it doesn't wind up being help, it winds up being that people of color are, as Teri said, expected to do it. And we should not be doing it. If there is a commitment to racial justice and to diversity and things like that, then that means it has to go both ways. So white people have to be committed as well as people of color. School administration officials are going to have to be committed as well as students of color. So it should definitely be an equal commitment on both sides, if that is to be productive.
All right,
Yeah,
I'm going to go
I
to
agree
our
with
next
everything.
question.
I don't have anything to add.
Sorry. I'm going to go ahead to our next question, and this one is really, I think it's really timely for here at Vermont Law School, because we actually do have student groups working on mandatory race curriculum or some sort of seminar or class that would be mandatory for students to take to kind of address these issues. So this question is for Zamir. This person asked, do you believe a mandatory law school course on race in the law/institutional racism would help law students navigate through these issues that have harmed our society for a long time?
Absolutely. I think that law has not gotten its fair due in terms of its role of perpetuating racism. A lot of times there's conversation about pretty much everything else, but there isn't conversation about the law itself. And having that conversation and having a course that focuses on that, I think, uh, first of all, helps people to understand, like Kira said earlier, that there is a big difference between morality and legality. I think it helps to deal with that issue because there are, unfortunately, way too many people in the society who think that if it's legal, it's moral, and if it's illegal, it's immoral. Slavery was legal, but it was immoral. And there are so many things that happen now where they might be legal, but they're not moral. And so I think a course that deals with race in the law will first off help to break that false chain between legality and morality. And then also it will help, I think, people understand just how racism operates in this particular society. I mean, to give a really easy example. So as I said, when I was talking, overt racism pretty much meets its end in the late 1960s. Then you have covert racism in the 1970s. And so now you start seeing coded where Black people are made synonymous with crime. And then after that, the Supreme Court pretty much starts stripping away at rights for people charged with crimes. They destroy the Fourth Amendment, they butcher the Fifth Amendment, they butcher the Sixth Amendment, they butcher the Eighth Amendment, they butcher the 14th Amendment. And then when it comes to challenging racial discrimination, they have shot that down. 1987, they came up with the case McCleskey versus Kemp, where they said there was not a constitutionally impermissible amount of racial discrimination in Georgia's death penalty sentencing scheme. Not that there wasn't discrimination, but that it didn't rise to the level of being constitutionally impermissible. And so when it comes to understanding exactly what we're dealing with, it was the law that erected that barrier, or the law that was in essence used to erect that barrier. And I also think that we have to bear in mind how law is used in contemporary times to erect barriers. So to give a clear example, I read today how the governor of Georgia passed or signed into legislation a new law that added enhanced police protections, where if you are charged with hurting a police officer or damaging over $500 of police property, you get charged with a crime that carries 1 to 5 years in prison. And if you're convicted of that crime, you must do that time consecutively with whatever other crimes that you're convicted of. You cannot do the time concurrently. And then it also empowers police officers to sue individuals who falsely accuse them of police brutality and things like that. Now, this is a law that on its face is neutral, but it's clearly targeting Black Lives Matter protesters. It's targeting people who are protesting police. It's targeting people who are seeking to hold police officers accountable. And this is the role that law plays very often. And of course, it does it in a racially neutral manner. So it's not going to say that it's targeting Black people, but it's clear as day the way it's written that it's going to be used in a manner to target Black people. And so I think it definitely needs to be taught because, again, if you're going to fight a problem, you have to understand how the problem works.
Thank you so much. We're coming up against time, but I wanted to ask one last question and then open it up to all three panelists. This person asked, in your respected careers, have you seen a change in attitudes towards race? If so, what has caused those changes? Are they positive or negative? Do you foresee a positive future?
Okay, so I'll go first. No, I haven't seen it. Um, in the criminal judicial system, it's taboo to even talk about it. Judges don't want to hear about it. prosecutors don't want to hear about it. And it's across the board in terms of race. Like, Black judges don't want to hear about it. Black prosecutors don't want to hear about it. You go into the system, you're going to operate within the cogs of the system. Most of them do. And it really doesn't matter. They don't want to hear about it. And so attitudes really haven't changed at all. I mean, you had the George Floyd killing, which you had a host of police brutality killings, Tony McDade, Breonna Taylor, a number of individuals, but George Floyd was the one that, got the most attention because of the fact that much of it was caught on video. And there was this big air amongst people that things are going to be different and that times are going to change. I can tell you one place where that air did not exist. It did not exist in the criminal justice system. Judges pretty much carried on the way they did, and it didn't make a difference. Now, it was a fantastic PR opportunity because Bronx prosecutors wrote this letter about, oh, we need to start holding cops accountable. Now, they're prosecutors. If you want to hold cops accountable, you can do it as prosecutors, theoretically speaking, especially since Bronx prosecutors or prosecutors generally have more interactions with police officers than anybody else. So if they're getting away with stuff, it's in part because you allow it to happen. And the same holds true with judges, where a number of judges issued a statement last month in which they too were talking about how we need to have, racial justice and racial equality. And I saw some of the names that were on that list, and I'm like, you're the biggest devils out there. Like, you treat Black and brown clients with no respect whatsoever. And the rulings that you make are terrible rulings. And yet here you are positing like you care. And it's clear as day that you don't. So in terms of, has it changed in the criminal justice field? No. I can't speak for other legal professions. But it's pretty much time has stood still. It really hasn't changed.
I mean, I'm part of the hip hop generation, and so I got into school in that sweet spot where I still was able to benefit from the protest of the 60s and the 70s. But going to law school and graduate school in the 90s, and then entering a career where we were in retrenchment, that people were starting to not listen anymore. And so, I'm from New Jersey. I went to Spelman College as an undergraduate and I went to graduate school and law school at the University of Iowa, and started my career in Des Moines, Iowa, where I was only one of 2 Black women in private practice in the entire state. And this was not in the 1960s. I'm not that old. This was in 2001. So, so just to give you an idea, what I saw was a period where we reached detente, where people weren't necessarily wanting to beat you over the head, but they weren't necessarily welcoming you into their places of work. And so I remember every time I'm an employee benefits attorney. I remember every time when I clerked, I got questioned about getting files from my judge. It was the first Black law clerk in the court where I clerked. In private practice, no law firm. You have to understand this. By 2001, the new millennium in Iowa, no private law firm had hired. They only hired one other Black woman before I came along. Right, this is 20 years, like 19 years ago. So it's not that things have been, I've seen things get horribly worse since 2016. Like, before then, I think there was a false hope that, okay, maybe, people are willing to talk, or at least it's not going to bother me. Like, I would settle for not being bothered, right? Like, just don't try to be a hindrance to my racial progress. Like, just leave me alone. But that's not happening now. And I was writing a response to a question. I just spent 7 years in Georgia. So I kind of chuckle when Zamir says, oh, people stop being explicitly racist. Now that's not true. My neighbor can send you pictures, celebrated all the Confederate holidays, had a huge custom made Confederate flag on his porch, and we were the only Black people on our street. So this was 2019. So now I live in the great city of Chicago, where I am not experiencing any of that. But I would say that we're in a time here where we're in a moment that we have an opportunity to either do something extraordinarily good, or we have the opportunity to break up our democracy until it's irreparably broken. And that responsibility rests with each of us in the choices we make every single solitary day. So, we have to be conscious and not be flip. And I can't expect Kira and Zamir, I can't be sitting on this call and be like, oh, they're going to handle it, I'm good, right? No, we all have a responsibility every day to do our part.
I can't, obviously speak to like any changes in personal experience with racism, but definitely speaking to seeing it, and seeing it not change at all in institutions. And what Zamir is saying about like the, criminal justice system, like you can't take racism out of something that's like been the whole point of it all along. And so like when we are looking for change and we look to institutions and especially the government, like knowing that what we're going to get, if we get anything, is like a performative change that, prioritizes like looking like it's a change. But that just really makes racism and these kinds of like systemic problems more insidious, but really driving them deeper, because that's the thing that like props a lot of these structures up. So I guess looking to like change happening the fastest and seeing that happen the fastest in young people. But, because like racism comes a lot of times from the structures of the world around us, like that's not going to happen just by getting rid of our individual racism, and just by making racism harder to see, by like making, discretion the way that it comes out rather than overt racism. And I think making sure that we ask for what we need and not what we think we can get, because that's like oftentimes where we settle for these more performative reforms.
Well, we are right up against time, but I want to thank all three of you for your expertise and for sitting down and talking with the VLS community and sitting down and talking with all the viewers today. I personally learned so much, and I really appreciate this. And I know our viewers appreciate such an honest and raw conversation, specifically directed towards the issues of racism we're experiencing in this country right now, and even in the microcosm of the Vermont Law School community. So thank you all so much. Thank you to everyone who watched for joining our 5th Embedded Racism in the Law panel. We hope you'll come and join us next time. But as for tonight, we are over and out.